Koopmans.
Thank you, Your Honor. May it please the court. Iowa Code Section 622.10 sub 6 places a duty on healthcare providers to produce medical records within 30 days of receiving a request by a patient's attorney, or an adverse party, who is usually, for all practical purposes, an insurance company, a defense law firm, or some other defendant in a lawsuit. That may seem like a simple task. It's not. It's much more complicated. We might envision that behind a nurse's station at every clinic and hospital, there's a file with our name on it with all of our medical records. That is not the case. Medical records are sometimes dispersed throughout the hospital, throughout the health system, on different terminals, in different media, and do not come in simply 8.5 by 11 sheets.
This is a motion to dismiss. Aren't you bound by the well-pleaded facts, and where the records are and how they're gathered is something that's not part of this record?
We are bound by the well-pleaded facts, but where the records are, how they're found as a general matter is a legislative fact that you may use to interpret the statute.
How is it a legislative fact? I mean, isn't it different hospitals and different clinics may do different things? Unity Point may have a central place, while the mom and pop clinic in Waverly, Iowa may have it in their back room. I mean... You may assume that, Your Honor. You may assume... Well, doesn't that have to be developed through facts? I mean, as I understand a motion for summary judgment, a motion for dismiss, we take the well-pleaded facts, take them as true, and decide whether or not the law applies or whether we can decide it. And so you can go ahead, but it seems to me that all that stuff's outside the motion to dismiss record.
The job or the issue at this stage on the motion to dismiss is to interpret the statute. And so you may use general matters that the legislature may have been aware of to understand what the legislature had in mind when it wrote this statute. And to move further on, the issue here is, when the statute says that a provider must do this, when the statute says that the fee charged shall be based upon the actual cost of production, what did the legislature have in mind? And I think from the statutory text there, you can assume that the statute regulates providers and only providers. And when it says that the fee charged shall be based upon the cost of production, it means the cost to the provider, the cost to the medical community to do this. And when a medical provider...
Counsel, what was the legislature's purpose in enacting 622.10? What problem were they trying to solve? Who were they trying to benefit?
My understanding is that there were people were charging inconsistent rates, is what I understand, and possibly in some instances too high of rates. And so the purpose, I think, from the statutory text is clear. It's twofold. One, to protect patients and the requesting parties to make sure that they don't, the charges aren't too high, because essentially each provider has a monopoly on that patient's health records. And number two, to make sure that healthcare providers are compensated for this onerous task, which is a regulatory nightmare, as many of you know, and a fact that you can tell from the law. HIPAA applies to all of these things.
Is one of those purposes thwarted if the provider can simply outsource the duty to provide records, and then the third party, your client in this case, charges too much?
Well, I'd say the opposite is true. The purpose is thwarted if the hospital can't outsource to a company like Healthport, who is a national company who develops processes, training, software programs that then it can spread across its customers throughout the entire United States. I mean, you can analogize it to, for example, the court system. Imagine if each district court had to develop the EDMS system on its own instead of the judicial branch doing that. The costs would be cost prohibitive. And so even if you have a large health system, if you prohibit them from outsourcing the task to a company like Healthport, then they're going to incur greater fees, and those fees then, Your Honor, will be passed upon to the patients. And so ultimately the patients won't be protected if you interpret the statute to prohibit companies like Healthport.
Hypothetically, if there's an overcharge, a fee that's just simply too high, who does the patient look to for relief?
Well, the statute places the duty on the healthcare providers, and by outsourcing this task, the healthcare providers don't outsource their duty.
Well,
So-
and couldn't we accept that argument? I mean, couldn't we say that we can't sue Healthport because the duty is the providers, not Healthport, but then leave for another day whether the providers in this case are actually complying with the statute? Because as Justice Wiggins points out, it seems like you're going outside the record and weaving in a lot of facts that may be true, may not be. I mean, it might be that Healthport gives a rebate back to the provider in return for the business. I don't know. So, you know, can't we wait and defer that issue for another day and simply say that the statute applies only to providers, not to third parties like your client?
Yes, and if you look just at the terms of the statute, it regulates providers, and so if there is some kind of cause of action that can be made through a vehicle like a breach of contract claim or just a private cause of action, it is against the providers only, and the matters that are outside the record, that goes towards the purpose of the statute. But I don't think you need to get to the purpose because you don't need to go beyond the plain language of the statute.
Have other courts and other jurisdictions reached this issue that you're aware of?
Many courts have addressed issues like this, never exactly like this. There are state statutes across the country that regulate the fees that providers may charge, but they're not like this one. Some of them say a reasonable fee, and that can include a profit, for example. Some of them say...
But it reached the issue whether or not a third-party provider is responsible rather than, I mean, a third-party provider like I don't want to use provider, a third-party person who puts the records together is responsible just as the provider is.
Well, some state statutes specifically say that the third-party providers...
What about the statutes that don't? Have you found any cases that say, even though the statute says providers have a duty to provide the record, when they outsource it, the outsourcer is responsible?
I believe there's a California case that said something to that effect. That statute, though, refers to reasonable fees. And again, so it doesn't create this absurd result in which healthcare or companies like Healthport are banned from doing business in the state if the statute applies to them.
Does Healthport have any other responsibilities or duties other than just produce the records?
Outside, within the confines of this case and this complaint, the duties are simply to provide the records on behalf of the petition alleges that the providers contract with Healthport to provide the medical records. The petition alleges that these plaintiffs or their attorneys requested the records and that Healthport fulfilled that request as the outsourcing company. I mean, essentially, as we noted in the brief, Healthport's role here is not that unlike Kinko's, and I hesitate to use the Kinko's example because producing medical records is more complicated than sticking them in the copy machine, but I think this makes the point. When I bring my briefs to Kinko's, or when I used to bring my briefs to Kinko's before EDMS, Kinko's would write in the cost of putting them together, making the 18 copies, putting the appendix together, listed on there, and then we would submit that cost certificate to the court.
Sure, but what if you took it to a Kinko's 2 and they did 100 pages and charged it $3,000? What would happen then?
Well, if it was like this case where the statute said somehow the fee had to be capped at a certain amount, or the court would see that, I think the court would say that's not a reasonable fee, and who would the court go after? It would not go after Kinko's, it would go after me. And it's the same thing in this case. If the fee exceeds what the providers could pass on, because again, Healthport's charges are the cost of providing these records, and if Healthport exceeds...
I mean, maybe, but and Justice Mansfield's point may take care of it, but you see the problem. The problem is the party with which the provider contracts with could have a default position. We're going to charge a maximum fee, no matter how simple it is. That statute allows us, we're capped, we understand. We're going to charge it as a matter of policy, and then it'll pass through, and that's the end of the day. Now, that strikes me as kind of a, quote, loophole. I mean, that strikes me as problematic. And I doubt that the legislature intended to endorse that kind of proposition. Now, it may well be that the provider is still on the hook and that the provider, has the burden of showing that the costs were appropriate under the statute. But don't you agree that if a third-party vendor had a default position that we're always going to charge the maximum fee under the statute, that would be problematic?
I think it depends as a practical matter on what the maximum fee is. If the fees in this case are not actually very high if you consider the work that's being done. And so when they charge that fee, And when the hospitals contract with them to do that, it is a reasonable fee. And I guess what I would go back to is say, the hospitals don't have any interest in allowing some third party to go crazy and bill, $100 for one page or $200 a page.
Isn't that a fact question, though, of whether it's a reasonable fee or not? I mean, the fees the hospital may receive back from SMART for doing it, we don't know what those are. Not SMART, Healthport. I mean, those are all fact questions. We're in a motion to dismiss here now, and we don't know what the relationship, we don't know what the actual cost is. We don't know what they're charging. We do know they're charging the maximum, but we don't know what the actual cost is to the provider on this record, because it was done in a motion to dismiss. And I think that's what the district court said. I don't know how to do this until we get the facts to get into these issues. And the Kinko thing's different. You pay Kinko, and then you pay Kinko, and then you put it on your cost things. I don't know if you pay Healthport to do this at that cost, and that's what the cost is to the provider. I mean, all these facts, don't they have to be developed if this Kinko argument has any life to it?
Well, responding to Justice Appel's question, it was more kind of a policy level argument question as to how should we interpret this statute. And that was what we asked the district court to do. And what the district court did is said that, well, I need facts to interpret the statute. And that's not necessarily true. And in fact, it's not true. The statute, the interpretation of the statute cannot change based upon what the discovery is in this case and what the facts are in this case. At the highest level, the statute applies only to providers, and therefore what Healthport's costs are relevant to the statutory interpretation question.
How do we know those are the actual costs without, as Justice Wiggins says, discovery? How do we know that's the same price they would charge if a clinic called up and said, we lost our records, we need a set of them? Would they charge the same amount? We don't know that. Isn't that a subject for discovery?
My response, Your Honor, is not that Healthport's costs are irrelevant. What Healthport charges is the cost of producing the medical records to the health system. And so that's the statutory.
Is that stipulated too? That seems to me, I mean, what concerns me is this kind of reminds me as I read the facts back when I was in practice, and you would be up against a New York law firm and, with those New York values, shall we say, and you would go to a deposition defending your client at the deposition, and then you'd order a copy of the deposition. It would be some exorbitant amount charged by an out-of-state court reporter, and you would kind of wonder, maybe, is that really their price, or is that just the price they charge me as opposed to the price they charge the New York lawyer? Isn't that a proper subject for discovery?
I think the only issue here is whether the statute applies to Healthport, and that's a statutory interpretation question. I think the answer is no.
Let's turn to that. If you read Section 6A, which is the one that limits fee, I don't see the word provider in it.
No.
And isn't there a question whether or not it applies to somebody outside the provider? I mean, 6A is the one that says the fee charged for the cost of producing the records shall be based on the actual cost of production. It doesn't say that the provider shall limit it. It says the fees, no matter who charges it. I mean, couldn't you read that both ways?
I think in the context of the entire statute that it's clear that it means provider. And that subsection A, there's 3 sentences to subsection A. The first 2 are written in the passive voice, and the third goes back to actually listing the object of the sentence, which is the provider.
But could a reasonable person read it either way?
I don't think so, given the rest of the statute, the context, which context matters, number 1. And number 2, the effect, I guess, of what happens if you do apply this statute to Healthport. If you say, as plaintiffs have said, it applies to Healthport, Healthport can only charge its costs, which means it can't really do business because business assumes making a profit, then companies like Healthport simply won't be doing business in Iowa any longer, and the hospital systems will have to do this on their own.
Other states have ruled outside of California that they can't charge more than their costs.
I don't know that any other state has, Your
Okay.
Honor.
Could you address the argument that Healthport, by contractually agreeing to provide this service for the providers, they are their agent, or they've assumed the legal obligations under this statute?
The arguments that are made in the petition is that Healthport is violating the statute. And by entering into a contract with these providers, Healthport does not subject itself to the statute. Healthport cannot violate a statute that does not regulate Healthport. If there's somehow a provision in the contract between Healthport and the providers that says, well, you won't violate this statute because it will get us in trouble, the providers, then that's a dispute between the providers and Healthport. The legal duty that this statute places upon providers is on providers only. And if Healthport, in acting as agent, somehow violates that duty or exceeds what a provider could do, then the recourse is against the provider. Thank you.
Thank you as well, Counsel. Biscoglia?
Good morning. I want to start with where we just left off, because that's a very good question. There are other causes of action in our complaint or our petition that even if 622.10 doesn't apply directly to Healthport, that would allow us to go forward in the case. For example, we pled unjust enrichment. And we don't know. We don't know what the contract between Healthport and these providers are. We just simply don't know. But for example, if they said, hey, we're not going to charge more than what this statute would allow, that would be an unjust enrichment if they are doing that. If they've injected themselves into the process, they've become a wedge between the patient and the healthcare provider, and then are profiting in a way that they said they wouldn't. So I think that's a very good question. We're here on a motion to dismiss. Now, having said that, it is our position that 622.10, subsection 6, applies to Healthport. One of the questions...
Can I go back a second?
Sure.
If this statute does not apply to providers, how are they unjustly enriched by charging a fee for their services? I mean, that if there's no limitation under the statute.
If they've promised not to charge more. In other words, if they've already entered into an agreement. And the perfect example of this is the violation. There's 3 violations that we've alleged. The first violation...
I get it now. You're saying the agreement, which we don't have because we're at a motion to dismiss.
Exactly.
May limit them to the statutory things.
Yes.
And if they are limited to the statutory things, they may be violating the statute via their contract, which you don't know about either.
Exactly. That's exactly the point. And the most clear cut of those, there's the 3 allegations that we made. And the most clear cut one is a patient, and this comes from subsection 6B, a patient is entitled to request 1 free copy of their billing statement. Healthport, every time I've ever asked for a copy of the billing statement, charges $20, even if it's 1 page. Why? Because under the workers' compensation guidelines from 1 to 20, they can charge $20. So they charge you $20 for 1 page. And they charge you a $2 delivery fee for it. So they're charging you for statement. And I guess when we talk about the absurd results, and the absurd result here is there is a statute that says a patient is entitled to 1 free copy of their billing statement, and here you have an entity that's charging for it. And that's the entity that has been tasked with delivering that billing statement. The other 2 areas that we have brought up specifically with regards to 622.10 is the delivery charge that is charged by Healthport. Let me tell you what the 3 are, and then I'll go back and tell you the process that we have to follow to get records. The third one is, of course, that because they always charge that capped amount, that there isn't a relationship between the actual cost of production and what they are charging for the medical records. So one deals with bills, one deals with the delivery charge, and then one deals with the medical records. Now here's the process that you follow to get your records. If you're the patient, you send a request to the provider. That's the only time you ever interact with the provider with regards to a request for a bill, a billing statement, I should say, or with regards to your medical records. Healthport then comes to you and says, here's the fee. You don't get those records till you pay the fee. They basically hold them hostage. And the fee is the maximum, and in the case of a billing statement, it's not even allowed under the statute. So I guess that again gets us to the question of why does this statute apply to Healthport? Well, as Your Honor pointed out, the statute does not have any limiting language where it starts talking about fees. The statute in 622A, for example, says that it's two sentences that apply. And it's much like a funnel. There's the two sentences that apply in 622 subsection 6A. The first one says that the costs or the fees charged must be based on the actual cost of production. And the second one says that they're then subject to the caps from the administrative code. The third sentence is really interesting.
When it says actual cost of production, is it reading in a reasonableness requirement? Because actual cost could be, you could have 20 people doing the cost. Is reasonableness read into the statute?
The actual language is based upon, when we talk about profit, Healthport wants to paint this doomsday scenario that the moment 622 applies to us, we're going to go out of business. Look, this is a monopolized industry, okay? And the legislature recognized that. The patient has no involvement in picking Healthport. The provider does. For all we know, they're getting kickbacks for it. I don't know. We haven't done the discovery to find out. But it's a monopolized industry where they are setting the prices for these records. And in a monopolized industry, court oversight to determine profits is fair. And yes, reasonableness would be based on the actual cost of production. What we're not here to figure out today is if 622 does apply to them, we're not here to figure out today who should bear the cost of the profits, whether or not it's the provider that has decided to outsource it, or whether or not there is a profit margin that can be built in what is charged to the patient. We have to go figure out what those costs are and then figure out what the proper vehicle is. Nothing in the statute has prohibited them from making a profit. And no one's saying that they can't. But the statute still applies to them. They can't just say, oh, one page costs the same as 20 pages, costs the same as 350 pages. That's what the statute prohibits. And even more egregiously, they can't charge for a billing statement when the statute prohibits them from charging for a billing statement.
Hypothetical. Let's say that you sought medical records from Unity Point or whatever, and they go to Healthport and say, Healthport and say, can you produce those records? And Healthport is unable to produce them. Is your claim against Healthport or against Unity Point?
That's a great question also, and I put a lot of thought into that. The duty to actually deliver the records is clearly a duty that is placed on the provider. The fees charged for the delivery of the records is one that is a right of the patient and is placed on whomever is delivering the records. In other words, if you go back and let's look at 6A and 6B, the two sentences in 6A that deal with the fee talk about the fee. The noun in there is the fee, and it states, A, that it has to be within, based on the cost of production, and then B, that it can't exceed certain caps. Then there's a third paragraph there, and it comes back to the provider, and it talks about an affidavit. And in 6A, it says the affidavit must be provided by the provider. Now, why does it say that? Why doesn't either you don't include the word provider there, or you put provider everywhere?
Let me give you another hypothetical. You request records. Healthport delivers the records by direct ships them to your office, and Unity Point sends you the bill. And you believe the bill's too high. Who's your claim against? Same bill as in this case.
I guess in that case, it would be the one that has sent you the bill. My position is it's the one that has sent you the bill.
you know, kind of, if you're from the standpoint of the healthcare provider, they can kind of avoid this issue just by making sure they send the bill instead of Healthport sending the bill, right?
Well, no, because it would still, the same issue would still arise. Are we talking about a bill for a billing statement? Because that's the clearest one here, okay? They can't charge for a billing statement. Whether it's the provider, whether it's Healthport, whether it's a billing company. In fact, you know, I mean, that brings me kind of back to the statute, which is 622 10 subsection 6B. At the end, it has two sentences in it as well. The first sentence says, the patient is entitled to a free copy of its bill. I'm paraphrasing, but that's what it says. It doesn't say from the provider. It doesn't say from a billing company. It just says that you're entitled to a free copy. You can't be charged for a bill. The second sentence now comes back to talking about an affidavit. And this time it's a little different than in the first one. It says the affidavit can come from the provider or a records custodian. And the importance there is, again, why has the legislature inserted language about who that second sentence applies to and not the first one? Because the first one is a right of the patient.
Let's take Justice Mansfield's hypothetical and say that Unity Point sends you the bill, and it turns out in your discovery, that's what Healthport charges Unity Point to do it. Wouldn't that be Unity Point's actual cost? And,
Sure.
And you would be sort of like fishing instead of.
Sure, but that's not the way it works.
We don't know how it works.
We don't know how it works. That's not the way, but it would still have to be based on the actual cost of production. Can we go back to the Kinko's example? Because I think it's a great example. I mean, here's what stands out in the Kinko's example, is if Kinko's, in this monopolized process, see, the problem with the Kinko's example is if Kinko's is charging $3,000, no one's going to go to them to get their copies of the records. They're going to go to somewhere else. And here, it's a different environment. There's only one copy of records, and they're in possession of the healthcare provider. And you have to go through the process of, in this case, going to Healthport to get those records. The consumer has no choice. And so let me flip that question around. So let's say that the provider hires Healthport, and Healthport says, we're not going to give you your records unless you pay us $400, which far exceeds the caps. And when you go to the provider simply says, no, you have to go to Healthport. You know, and the problem here, because the question becomes one of, well, who, and it's been raised in the briefs, who do you sue? Well, you have to look at the timing in the basis of the lawsuit. We're not saying that they didn't meet the obligation to give the records. They did. We're saying that the company that did it is overbilling. And that's exactly what the legislature was trying to prohibit. I mean, is each patient supposed to go and file a lawsuit each time they get a bill for a billing statement? Is that the process that the legislature really wanted in place for patients to be able to get a free copy of their billing statement? So, I guess I submit to the court, first off, this issue is not dispositive of the entire lawsuit.
If you read the district court order, it's sort of cryptic. I mean, it doesn't really say anything, but it's sort of cryptic. What is your take on what the district court did and why they said this wasn't subject to a motion to dismiss?
I think the district court wanted us to do discovery, to see what the relationships were between the parties. And in part, you know, when we argued in front of the district court, it was very similar to this. We did argue the application of 622 subsection 10, or 622.10 to Healthport, but we also talked about the fact that there are other claims as well.
I sort of read the ruling that I can't decide this case, or I can't even interpret the statute until I know the facts. I mean, did you get some of that from the ruling? And
I
if
did.
you did, why is it necessary to determine the facts to interpret the statute?
Well, I did, and I guess one thought about that would be the delegation of duty and how there was an interplay between And it raises a whole different question, and we can't really argue it today. We talked about it in our brief. I mean, can one party delegate their statutory duty to another, and then does that third party have to meet the statutory duty? But we have to know what level of the delegation is. We have to know what the contracts were between the parties.
Could the legislature resolve this simply by saying provider or its designee?
Perhaps, but the other hand, the legislature may have thought that by putting an absolute in there, i.e. a patient has the right to a free bill, that they resolved it. So, I mean, if you start with just the plain language of the statute, which is where we start, I mean, it has a pretty plain statement. Nobody should choose it.
I understand the attractiveness of a global ruling to resolve this, but how do you address I mean, isn't one option for the patient that wants a free copy of their bill is they go back to the provider, say, hey, I'm entitled to a free copy of my bill. I don't have to pay Healthport $20.
And we do that all the time, and we get sent back. That's what once you request the records, there you go. You're off to Healthport. And so, as a practical matter, that conversation doesn't happen, and that opens me back to every time you feel like there's going to be an involvement of Healthport, you have to file a lawsuit to compel the free billing statement. And on top of that, Healthport's already collected this money. I mean, they're the wrongdoer here. They know what the statute says. They know they shouldn't be charging for billing statements. They're the wrongdoer.
Mr. Biscoglia, when was this statute enacted?
I don't know off the top of my head. It was within the last, I believe, 5 years.
All right, thank you.
You're welcome.
Rebuttal?
Thank you, Chief Justice. The statute was enacted in 2008, I believe. I want to pick up Justice Mansfield with your hypothetical about what happens if the provider sends the bill instead of Healthport. And I believe the concession was, well, then Healthport's charges really would be the cost of production, and that would be okay. And so all we really need to do is funnel the bill through the healthcare provider, and then everything is okay. I don't think that you can get from this statute that that's what the legislature intended, because all that is going to do is raise the cost of producing these medical records. And if it's a cost that can be passed on to the patient or the requesting party, which again are often defense firms and insurance firms, then it will. If it's a cost that then at that point exceeds the cap and therefore the provider has to bear it, the provider won't bear it. Eventually, it will be passed on in terms of increased healthcare costs. Most providers, most health systems are non-for-profit entities, and so if what the legislature was doing is just simply making it so we had to go through unnecessary steps, then that's going to raise the cost of healthcare. The billing statement issue, I want to break that out from the issue of what cost is, because the billing statement issue really is if Healthport has indeed charged for a billing statement where the statute says that a provider cannot do so, then they may sue the provider and seek the relief there. I think there's some confusion about what that $20 fee is, but they have alleged that it was for the billing statement.
Is that what the legislature intended to do? Let the hospitals give it to some third party and then require each individual patient each time to sue the provider who they're asking from? I mean, is that really what the legislature did by setting up the statutory scheme?
Well, if Healthport is violating the statute and the statute applies directly to Healthport, then each time the patient will have to sue Healthport. I don't know that the number of lawsuits would be any different depending on who's charging.
This is trying to move ahead as a class action, which hopefully if they're right, we'll have some remedial relief. If they're wrong, then you're left to suing each person. And does that seem what the legislature intended everybody to do?
We'll sue each provider. Many of the providers are very large.
For a $20 bill, a $60 court cost. I mean, is that what they intended every time?
I don't know what they intend vis-a-vis class certification. I don't think they probably
Eventually, though,
thought about that.
I mean, it seems like if the legislature thought of this scheme, that they'd want, when someone got charged $20 for a bill, they have an $80 court cost against Unity Point when they're going to win. I mean, I don't see any way around it. So they want the hospitals involved in a suit and a patient involved in a suit every time?
Well, let me take your question about kind of class certification and then turn also to the issue about what our costs are. And if plaintiffs are right, if we can only charge our accounting costs, the dollars and cents that we actually expend, then I don't see how you can ever certify a class in this case, because each individual request is going to be very different.
I don't want to get into certification, because that's not an issue. See, one of the things that bothers me about costs, not just in this area, we have a statute that says when you file a brief, and we're electronic, so it's not as bad anymore, you can charge the cost, to be taxed the other side of the cost of printing the briefs. My 10 years on the court, some people charge 5, 6, 7 cents a page, 10 cents a page, a quarter page, and some people charge the $4 maximum according to the rule of civil procedure and rule of appellate procedure. And it seems to me that what the legislature was doing here is trying to avoid the situation we have here, saying that you could only do the actual cost up to a maximum, instead of avoiding people just throwing the maximum cost on. And we've had people do that here for years. I'm not going to name the law firm.
But hopefully not ours. Cost is an issue, and that's kind of lingering out there, right? I mean, I think the plaintiff's counsel said something about how this is like a monopolized industry. And if you are going to analogize it to a monopolized industry, well, then cost actually includes some kind of accounting profit, or excuse me, some kind of economic profit, economic cost, opportunity
That should be
cost.
figured out later. I mean, if they get past this, I think those issues are all open. But the question, I think, is your question, and I think somebody framed it right. Does this statute apply to third-party providers of records? And that's clearly the issue before us, isn't it?
It is, Your Honor, and I think the answer is no, based on the language of the statute, which talks only in terms of a provider, speaks only in terms of a
Mr.
provider.
Koopmans, are there any legislative facts regarding the existence of this third-party provider process at the time the statute was enacted? Are there any legislative facts that tell us what the environment was when the statute was enacted?
I don't know that there is any legislative history. I know that, just generally speaking, the documents that I cited, for example, the 2004 report on what it takes to produce records, who produces records, those kinds of facts were available to the legislature, but what the legislature read, what they considered, is unknown.
We don't know whether or not the problem that has surfaced in this lawsuit was a problem, or it was a problem that existed or could have existed in 2008?
We do not.
Can we take into account those legislative facts if they're available?
Legislative facts in terms of,
What was going on in the legislature's mind when they enacted this statute?
if you have credible sources of what the legislature was
Because I
saying.
know you moved to strike all that stuff that had all that in there, and we struck it because it wasn't down below. But if you think we could look at it, maybe we should take another look at that motion to strike.
No, what was submitted by the Iowa Association for Justice was not proper legislative history or legislative fact. There was an affidavit about conversations that a lobbyist had with legislators, and what he understood the legislatures to believe about the statute. That's not appropriate legislative history. But generically, at the highest level, what are release of information vendors, what were some of the concerns in publications that could have been out there? Those are proper things to take into consideration, just like a dictionary definition is something that you can take into consideration.
And concerns of other courts also, I would take it, with similar statutes.
Yeah, if there were published decisions that were out, the legislature may have looked at that and said, well, we don't want that problem here. Absolutely.
You may sum up.
Thank you, Your Honor. We ask that the decision of the district court be reversed, that the case be dismissed because Healthport is not a provider, and if there are some issues that plaintiffs still have, they can take those up with their provider. Thank you.
Thank you as well. The case then is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.